Recording in progress.
Good afternoon, everyone. Thank you for joining this webinar, which is our first webinar for OTB Legal. My name is Sally. I am a director and head of the business immigration team, and to my right is my colleague Lydia. Hello. Lydia is an associate solicitor. In the background we have my colleague Sam, who's an immigration advisor. Sam will be dealing with any kind of technical issues this afternoon, so if you've got any problems or you can't hear us, then just pop that into the chat, please. Now, the webinar invitation went out to you for 2 hours. We envisage speaking for about an hour, and we will take any questions at the end. If you could put your questions into the Q&A box, we will go through these and go through them at the end for you. We do have a short poll just to see what kind of progress and stage our audience is at in terms of their sponsor licence. So if you could just very quickly put your answers to the poll, and then we can begin today's webinar. Thank you. So I can see that most of you have already been granted your sponsor licence, and so we have another short poll just to check on your confidence in terms of your sponsor obligations. So how do you feel about your sponsor obligations? So most people are somewhat confident. We're somewhere in the middle, some not very confident, and some people have no idea what they're doing, and some people are very confident. Fantastic. Thanks very much. So, today we will be covering the basics, your duties, your right to work checks, and including the recent changes. And as I said earlier, please feel free to raise your questions in the Q&A box, and we will deal with these at the end. The basics. So the Home Office consider that your ability to sponsor migrant workers is a privilege, and as such they place significant trust in sponsors to comply with UK immigration law and wider UK law. You are expected as a sponsor to ensure that the system is not subject to abuse, and you must monitor your migrant workers and meet all of your obligations. So compliance with your duties, as I'm sure you're all aware, is absolutely paramount. Your duties as a sponsor commence on the day that your licence is granted, and they continue until you either surrender your licence or the licence becomes dormant, or you let it expire. Whilst you hold your licence, the Home Office are entitled to make announced or unannounced visits to your premises. Announced visits are more likely within the pre-licence period before you're granted your licence, just to check that you can meet all of your obligations as a sponsor. Unannounced visits tend to occur where the Home Office have... Sorry, we're just turning the air conditioning off, it was a bit loud. Unannounced visits occur usually when the Home Office has received specific intelligence about the practices of an employer. This light trigger approach means that the Home Office can revoke or suspend your licence on the basis of relatively minor breaches. Other options open to the Home Office are downgrading your licence, so you could become a B-rated sponsor, which will have an impact on your ability to sponsor workers. You won't be able to issue any new certificates if you're B-rated, and you have to work quite hard to go back up to that A-rated sponsorship. Or the Home Office may require you to undertake an action plan. Now, action plans are dealt with within the sponsor management system, and they're quite costly. You have to pay the Home Office to set up and operate your action plan. So, sponsor duties. There are a number of duties that you have to comply with as a sponsor. First of all, reporting. So although it's second on the list, I'm going to deal with that first. There are lots of reporting duties that you have as a sponsor in relation to your business and in relation to your sponsored workers. So there are different time limits for when you need to report different things. If you are reporting a change in circumstances for your migrant worker, for example, if you don't sponsor them anymore, if they've left your employment or have been granted indefinite leave to remain, or there's a significant change in their terms and conditions, then you have 10 working days to report that on your sponsor management system. If there are changes to your company, so changes to the company structure, you change a company name or a branch name, then you have 20 working days to report that in your sponsor management system. You also have a duty to comply with UK immigration law. So you, for example, you can only assign certificates to workers who are appropriately qualified, and compliance with wider UK law just refers to employment law, so you make sure that your workers have paid holiday entitlement, and obviously you have a duty to prevent illegal working. In relation to not engaging in behaviours or actions that are not conducive to the public good, I'm sure none of the examples that are set out in the Home Office guidance will apply to any of you, but you are obviously not allowed to foster hatred or practice discrimination in the course of your business. This brings us on to record keeping, which is the focus of this session today. And I will now hand over to Lydia to deal with the record keeping requirements.
Okay, thank you very much, Sally. I'm just going to move the presentation on. Okay, so thank you very much. When I started putting this presentation together, originally the plan had been to give you sort of a brief overview of all of the sponsor obligations together. And as we started putting it together, I think we realised that actually it would be more useful to go in depth into one rather than trying to do a broad brush of all of them. And the simple reason for that is, as Sally's just outlined, the Home Office expect you to have a very good working knowledge of what your sponsor duties are. And so giving you a broad overview is not necessarily that helpful to you. And on balance, we went for record keeping. The reason we went for this one is because first of all, there are some of the records you have to keep are probably things that you're going to have anyway, but some of them are less intuitive or less obvious, and sometimes if you don't get them at the time that at the relevant time, then they can be more difficult to rectify later. So that's why we plumped for this one. So I'm going to work through all of the documents that you need to retain. And where there are particular issues with them, where they relate to other duties, for example, I'm going to explain that. I'm going to explain why you need to keep some of these things, because sometimes I think that makes it easier to remember, and also it helps to keep in mind your broader obligations. So the first thing that you need for all sponsored workers, you need to do a right to work check for them. Sal's going to be talking about right to work checks in more detail at the end. Goes without saying, you need a copy of their passport on your file, and a copy of any visa that they have that allows them to work for you. Now, the second two bullet points on here are less obvious, and these are things that really often catch people out. So the first thing I say is that these only apply where you are sponsoring someone who is applying for entry clearance. Now, what is entry clearance? Entry clearance is when you're sponsoring someone who's currently living outside the UK and they're applying to come into the UK. So if you're employing someone who's already here, maybe on a different type of visa, or they're here working for another sponsor already, this isn't something that you need to worry about so much. But where you are sponsoring people for entry clearance, you need to make sure that you have some evidence of the date that they physically arrive in the UK. The majority of workers who are being admitted for entry clearance will get what's called a vignette in their passport. A vignette is basically a sticker that it usually takes up pretty much the whole of a page in their passport, and it sets out the basic terms and conditions of their visa. That vignette will be valid for a certain set period of time. At the moment, they're being issued for 90 days, and they will have a valid from and a valid to date on them. Not all sponsored workers will get those. In particular, workers coming from EU countries are now getting digital-only visas, so they don't have a physical vignette in their passport. However, either way, you need to check the date that they arrive. The reason that you have to do that, because it seems a bit of a strange thing to have to do, is that there is a significant risk sometimes, particularly for the people coming from countries like the United States, Australia, New Zealand, that if they arrive in the country too early, then they will be admitted as visitors. So essentially they're being allowed in as a tourist. And tourists and visitors do not have the right to work in the UK. So if they arrive too early and they start working for you, then first of all, they may be working unlawfully and you may be employing them unlawfully. So for workers who have a vignette in their passport, ideally you should get a copy of what's called the wet ink stamp. So that's the stamp that the immigration official puts on their passport, showing the date that they've arrived at the airport. You won't always be able to get that in every case. So for example, if someone enters through Ireland, they probably won't get a stamp. And again, EU workers and some what we call non-visa nationals, people from countries like the US and Australia, they can enter through the e-gates at the airport and therefore very often won't have a wet ink stamp. In those cases, you should still check the date that they arrive. The Home Office suggests checking things like a travel ticket or boarding pass. I've even known people use something like luggage tags off their bags as evidence of the date to arrive. If you're checking those things, strictly speaking, you don't need to keep a copy of the actual luggage ticket or the boarding pass. You just need to keep a record of the date that they arrived to show that you checked it. That said, if your worker has no objection to you retaining a copy of their boarding pass, that might be an easier way to deal with it. But it's a good example of something that if you're not aware that you need to do it, getting that boarding pass back in 2 years after they arrive is going to be tricky. Okay, so the next sort of category of documents that we are going to be looking at are documents related to recruitment. These fall into two categories. So for those of you who had a sponsor license before, I think, December 2020, you may remember the old resident labour market test. For those of you who had to do the resident labour market test, I'm sure you will remember it because it was a frustration for all of us who had to deal with it at the time. For those who have maybe got their licence more recently and didn't have to do the resident labour market test, this is not necessarily that relevant to you. If you're dealing with skilled workers or intra-company transfer, the new global mobility, then this isn't something that you would need to do now. However, if you did have to do the resident labour market test for workers that you've recruited pre-December 2020, you do still need to maintain the records that you had to keep as part of that old test. For the uninitiated, the resident labour market test required you to advertise posts in an extremely prescriptive fashion before you were able to appoint an international worker to those posts, and you had to keep extremely strict and specified evidence of running the resident labour market test. So you do still need to keep that if it was relevant at the time. I've set out on the slide usually what that meant. You generally had to take a screenshot of any advertising that was run. It always had to be run in 2 locations. Very often one of those places had to be the Job Centre website, and one other place Almost everybody in reality ran the resident labour market test by using internet sites rather than, say, advertising in the press. There are a small number of visas where you still have to do the resident labour market test. Religious workers, I believe, still need to run the resident labour market test, and if you are recruiting ministers of religion, then this will still be relevant to you going forward. As well as keeping records of the actual advertising that you ran, you also had to keep very prescriptive information about who applied for the role. So you had to keep a record of how many applications you received in the form that you received them. You had to keep the applications of anyone who was put forward in the process for shortlisted for interview, for example, or put forward for any other recruitment process that you might have if you ran aptitude tests for something like that. You're required to keep details of the names of all applicants, interview notes or equivalent if you used a different sort of procedure, and records of why particular candidates were selected, or why, if for example they decided not to accept the role. A small number of organisations would use what was called a university milk round. If you're not sure about a university milk round, these are typically a process where you would, it's usually for larger employers who essentially go around graduate recruitment schemes and will take part in recruitment actually on campus. If you used a graduate milk round, a university milk round, then you needed to keep a copy of the letter from each university confirming when you ran the milk round, and also the method of selection used. So if they did presentations or if they did interviews, for example. Those letters needed to come from each university on headed paper signed off by them. Going forward, the requirements for document retention on recruitment are less prescriptive than they used to be for most roles. I'm focusing here particularly on your skilled workers on these ones in particular for skilled workers, because I think that's the majority of the queries that we tend to get. However, you do still need to keep some evidence of the recruitment process that you go through. The upside to this is that the resident labour market test was extremely prescriptive, and that often made it challenging for people to meet perfectly because the requirements were so stringent. The upside going forward is that we do have more flexibility as to what you can maintain, and the approach taken by the Home Office going forward is perhaps more realistic and reflects better the realities of any recruitment process. The slight downside to it is that where it is more flexible, we also have less certainty. So it's more difficult perhaps to know for certain exactly what a compliance officer would consider acceptable. However, there is guidance laid out. If you do run advertising for a role, you must retain copies of that advertising in some form. It doesn't have to be screenshots anymore, it can be in a different format. But that remains mandatory. If you are advertising a post and then sponsoring someone to fill it, you do need to keep copies of the advertising that you ran, and it should also show where you advertised it and for how long. You still do need to keep records of who applied, of how many people applied, and also how many people were put through to each stage of the recruitment. You no longer need to maintain such excessive records really of the names of people applying and the actual copies of their application, but you still need to maintain some data as to who's applying and how many people are being put through for interview, for example. Thereafter, you should also retain at least one other form of evidence to illustrate your the recruitment process that you use. But again, you've got more flexibility in that than you used to. So you could simply retain, if you're using a scoring matrix or you have a set of questions that you are asking all candidates in an interview, you could keep a copy of that. You could maintain the interview notes for the successful candidate, for example. The guidance also allows you to maintain simply a written note of who you appointed and why other candidates perhaps were not successful. So you do have a lot more flexibility in that, but it is important that you do retain something. There may also be cases now where actually, and I think this happens more perhaps than the Home Office realise, that you appoint a candidate who you don't find through open advertising to the public. So, for example, you might recruit someone who you've worked with before in another role, or who comes on, or who makes a speculative application, for example. We are open to use those now in a way that we weren't previously when we had to deal with the resident labour market test. However, where you are recruiting someone on that basis, you still need to think to yourself, how am I going to show a compliance officer that this is a genuine vacancy and that this person is suitable, or the most suitable person to carry out this role? And you do need to ensure that you've got evidence on file already to explain that, rather than just having to make it up on the hoof in the event that you do receive a compliance visit. So if you've received a speculative application, still retaining things like interview notes of that you use, or as well references, taking up references, particularly for people who approach you on a speculative basis, or anyone who's come to you perhaps through a personal recommendation. Even if you worked with somebody before, keeping a record of that, but also keeping, again, interview notes and still taking up references would be advisable, I think. If you are an organisation that uses a university milk round, if you are, you're going to know about that. If you do, then the requirements for the documents you retain still haven't changed, I'm afraid, which is still quite an onerous requirement, actually, to get a letter from every single university on headed paper setting out all of that information. But if that is something that you do, then you should still be retaining much the same data as you were before. Why do the Home Office want you to keep all of this stuff? These documents, almost all the documents the Home Office are asking you to retain, are because they evidence your sponsor obligations or the immigration rules in some way. One of your obligations is that you should only offer you should only sponsor a worker to fill what's called a genuine vacancy. And among other things, a genuine vacancy, first of all, is one that hasn't just been created in order for you to be able to get someone a visa. There has to be a genuine role there, and a genuine need for a person to fill that role. And you need to be sure that the person that you are recruiting is suitable to fill that role, that they've got the necessary skills and qualifications to do it. And the Home Office will look for evidence that this is in fact a genuine vacancy. These documents are all going towards that. They're going towards showing that you have checked diligently to make sure that the person that you're recruiting is suitable, and that this isn't simply, I suppose, a ploy in order to get a visa or sponsorship for a particular person, perhaps for some other reason. Okay. The third category of documents that you need to maintain are employee records. The good thing about these ones is that a lot of these documents are documents that you're going to have to retain anyway. So in most cases, a lot of these things should not be overly onerous. Goes without saying, you need to retain copies of pay slips, and those should show any allowances that you're paying. They should be itemised clearly. That should be the case anyway. If you're issuing lawful pay slips, which you are required to do, they should be showing any allowances split out clearly. From our point of view, one of the reasons that is important is because certainly going forward, for skilled workers, you can only really include basic pay when you're working out whether the salary that you are paying is sufficient to meet the immigration rules. So things like shift pay, for example, are no longer acceptable to be included. And for that reason, it's important for the Home Office to see those allowances split out. Previously, under the older rules, you were allowed to include certain allowances, but there were certain ones that were excluded. So again, splitting out the allowances is important for that reason, to show compliance with the immigration rules. They also want to see evidence of that money actually being paid to the worker. So usually for most employers, that's going to be evidence of a bank transfer, essentially, of their salary into their bank account. And that needs to be specific to the worker. So you can't just have an item on a bank statement that shows £25,000 being allocated for wages. The Home Office are looking to see that what you've said in your contract and what is put on the payslip is actually arriving in the worker's bank account. That's what that is for. You need a signed contract of employment or written particulars, Section 1 statement. Again, Section 1 statement is a requirement in underemployment law anyway. It surprises me the number of occasions I come across sponsors or businesses in general that don't have contracts of employment. From our point of view, from the point of view of the Home Office, they're looking particularly to look at the start date. They want to see the hours, the job title, and an indication of what the person is going to be paid. The thing that a compliance officer would do in the event of an audit is they're going to be looking for consistency. So they're going to compare the information that you've put on a certificate of sponsorship against what you've written in the person's employment contract. And it's really, really important that all of this information tallies up. It can be tempting, I think, sometimes to be maybe less precise than you might be on a certificate of sponsorship, but it's a really dangerous thing to do. So, for example, if you say on a certificate of sponsorship that someone's working 39 hours a week, but your contract of employment says 40, that can be the difference between you paying them enough to meet the requirements of the immigration rules and not. So that 1 hour, if you're particularly in cases where you're really quite close to the minimum amount required for the immigration rules, that can be really important and could potentially cause you significant problems down the line if those things don't match. In terms of job title, pay, again, obviously they're going to be comparing against what you've said on the certificate of sponsorship to make sure that you are paying what you've said. But also job title, and this goes as well to the next item, job description. They're going to want to see that matches what's on the certificate of sponsorship. You need to maintain a detailed job description. In the event of a compliance visit, there's a very high chance that any sponsored workers that you have would be interviewed. One of the key things they're going to be asked about is to provide probably quite a detailed explanation of what they do every day, of what their job actually involves. And they're going to want to see that what you've put on your certificate of sponsorship matches what's on your job description and matches what the person is actually doing in reality. They're going to be checking that you haven't exaggerated the duties in order to make someone eligible for sponsorship who might not have been otherwise. They might equally check that you haven't underplayed the job. So, for example, you might have underplayed the duties in order to get someone into a SOC code that pays a lower salary, or you might have sort of adjusted the duties in order to put someone into a shortage occupation role. I've come across all of these at some point or another. They will be alive to that, so it's vital that that job description is a realistic and fair assessment or description of what a worker will be doing. You also need to think quite carefully about what you put, what you really need in terms of essential skills and qualifications in the job description. And this also goes back to your advertising as well. So if you list certain skills or qualifications as being essential in your job description or in your advertising, then if you're going to sponsor a worker to fulfill the post, you need to show that they have the skills or qualifications that you have said are essential. If not, you are at risk of the Home Office saying that this person isn't suitable and therefore it's not a genuine vacancy. I think in some cases it can maybe be a little bit tempting to include a bit of a shopping list in a particularly in recruitment advertising of the skills and qualifications that you require, but just keep in mind that any sponsored worker that you sponsor must have any of the skills and qualifications that you've listed. And if you do list essential skills and qualifications, then you need to keep copies of those. So if you've requested, if you say it's essential someone has a BA in Fine Arts, you need to have a copy of someone's BA in Fine Arts on your file to show that they have that they actually have that qualification. If someone needs professional registration, it goes without saying you need to keep a copy of that. So if they need to be registered as a nurse, for example, then you need some evidence to show that they are indeed registered as a nurse. Another couple of things to be aware of. If someone needs a DBS check, you should keep a copy of that. And you should also keep records of workers' addresses as they are employed by you. That's a complete record. So if someone moves house or changes their phone number, for example, you should keep a copy of the new contact details, but also keep a record of the previous ones as well. If you cease employing someone, you will be asked to provide the Home Office with their most recent name and address, and essentially the Home Office outsource that obligation onto you. They don't have really the wherewithal to maintain a perfect record of someone's contact details, and they require you really to do that for them. You should also maintain, and again this is something you'll probably be doing anyway, but you should also maintain a full absence record for all of your sponsored employees, showing things like annual leave, any time taken off sick, maternity, paternity pay, or any other unpaid leave that they take. Again, the reason for that is to show that there's no point at which you should have stopped sponsoring them. So if you have a sponsored worker who is on unpaid leave for more than 4 weeks in a year or in a 12-month period, and certain exceptions don't apply, then you need to stop sponsoring them. If they're off sick or on maternity leave, then that doesn't apply. But if, in many cases, if they are off for more than 4 weeks unpaid or not on full pay, then you have an obligation to stop sponsoring them, and the Home Office will want to check that you've complied with that obligation. So that covers most of the things that you need to be retaining, particularly for skilled workers. How long do you have to keep all of this stuff? A lot of these documents will have separate requirements for you to retain them. So tax records obviously have to be retained for periods in line with the HMRC requirements. People generally keep a lot of HR records for 6 years after the time that someone leaves anyway for other reasons. But from the Home Office perspective, you either need to keep them until at least a year has passed since you stopped sponsoring someone, or if you do have an audit and a compliance officer sees the documents and says that they're all fine, then if you don't need them for some other purpose, you can get rid. On the first point, from 1 year has passed since you stopped sponsoring a worker, one thing it can be worth bearing in mind is that if you have a sponsored worker who moves on to a different type of visa, most commonly if they get indefinite leave to remain in the UK, then actually you don't need to sponsor them anymore, and you should be reporting that to the Home Office. And again, it's something that catches people out, because you would think that the Home Office know that they've granted your sponsored worker indefinite leave to remain because they granted the application. Nonetheless, if that does happen, you are supposed to report it and cease sponsorship. So it's worth just letting any sponsored workers that you have know that, so that they are aware that if they do switch into a different visa, or if they do get ILR, that they should let you know so that you can just make the relevant report. It's also useful for you from a record keeping point of view, because as soon as you've stopped sponsoring someone, that 1 year starts from which you don't need to retain all of these documents necessarily anymore. So that is the end of my section on record keeping. And I'm now going to hand back to Sally. Sally is going to look at the recent changes on right to work checks, which came in April, and there's some fairly significant changes there for you to be aware of.
Thanks, Lydia. That was really, really helpful. So, right to work checks. Why are they important? It goes back to your original obligations in terms of compliance with wider UK law, and right to work checks are required to prevent illegal working. More importantly for you as employers is that provided you've conducted a compliant right to work check, you will have a statutory excuse if your employee later turns out to be an illegal worker. So, who do the right to work checks apply to? So, you have to check everybody's right to work. It doesn't matter where they're from. It is non-discriminatory. You must check everybody's right to work, every employee from every nationality, whether they are sponsored or not. These checks must be carried out prior to employment commencing. So if it is your practice to ask your new employees to bring their right to work documents with them on their first day of employment, you will need to think about staggering their start time. So if they are due to start at 9 a.m, you will need to conduct a right to work check, so they shouldn't be employed until 9:30 when you have conducted that check and confirmed that they have the right to work in the UK. If they forget their documents on that first day of employment, you should be sending them home and delaying their start date. So you are not at risk of employing illegal workers. So the changes that have happened this year, these are quite significant from the 6th of April. The first thing just to bear in mind is that these changes will not have retrospective effect. So if you have relied on a BRP, a biometric residence permit, for example, before the 6th of April, you can still rely on that. You don't have to do follow-up checks. But the Home Office are now moving towards being online only for all right to work checks. There will be some circumstances in which you still need to conduct manual checks where the online checking service is not quite up to speed yet. Where you are making manual checks, this tends to be where you have British or Irish citizens, Irish passports, Irish passport cards. Where you're completing these manual checks, you need to make a note of the date and time of that check and the fact that the document was checked in the presence of the individual. Some employees you will not be able to do manual checks on now. So, for example, EU nationals are all granted e-visas now, and people who have applied for status under the European Settlement Scheme. So you will have to check those details online. Where you are checking online, online checks. So all people who are able to have their right to work checks completed online will have access to a share code. So your EU workers at the moment will all be able to prove right to work by generating a share code, which is valid, they will give to you as an employer, and that is valid for 90 days. You can check those details through the view a job applicant's right to work details using the share code and the date of birth, and what should pop up on the screen is a photograph of your job applicant, of your employee, and details of their permission to stay in the UK. You need to check that the individual that you are employing matches the photograph of the individual on the electronic online right to work check, and you must retain a copy of that right to work check. Where we are running into some issues is the fact that now biometric residence permits are no longer accepted as valid right to work check documents. So when people from outside of the European Union are applying to come into the UK to work, they will be given, as Lydia said earlier, an endorsement, a vignette, a stamp in their passport which says what category of migrant they are. So they're coming as a skilled worker. It will have their certificate of sponsorship number on there, and it will have the dates of validity on there. So at the moment these are 90 days, but they used to be 30 before COVID. Where your sponsored worker is coming into the UK on a vignette, they are able to work on that vignette before they pick up their biometric residence permit, but you need to take a note of the date that the vignette expires, because after that expiry date you will no longer have a statutory excuse if that person is not allowed to work. Workers should be encouraged to collect their biometric residence permits as soon as possible. These are usually collected from the post office, unless you're a really large sponsor and all of the biometric residence permits are sent to your company. Your sponsored workers will then be able to create a share code online using the information that is on their biometric residence permit. So it's a bit more of a kind of long-winded system now. So if your worker is starting work immediately, you can rely on that vignette and take a copy of it and note the expiry date of the vignette. When your worker picks up their biometric residence permit, you will need to repeat the right to work check with the share code that's been created from the information contained in the biometric residence permit. Now, only your employees are able to create these share codes. So even if you are a large sponsor and you help a lot of your workers with their applications and it's your email address on the application, you will still not be able to create that share code. It has to come from your employee. So you need to be diarising dates for when these repeat checks need to take place. And then obviously you need to retain a copy of that for your HR files. In a slight difference, so there is some contradiction here, and as Lydia said, there are different rules for different types of documents. Where you are keeping right to work documents, you must keep those documents for the duration of the employment plus 2 years. Where you need to carry out follow-up checks, maybe in a situation where your employee has their leave is expiring and they're applying for an extension or indefinite leave to remain, but they don't have a Home Office decision by the time their current leave expires. That does not mean that you have to stop employing them, because provided they've made an in-time application, they will benefit from what is called Section 3C leave, which has the effect of automatically extending their status by operation of law. But it does mean that your right to work check will be out of date, and so you will need to use the employee checking service to make sure that that person still has the right to work whilst they're waiting for a decision. Now, we've included this identity service provider because the Home Office say that this is going to be rolled out at some point in line with the rest of their kind of online right to work checks. Now, the identity document validation technology is supposed to check the validity of a British or Irish passport. Now, there are identity service providers or there are supposed to be identity service providers who will undertake the work of checking these identity documents to verify that identity of the applicant or the employee and their eligibility to work. But at the moment, there are no certified providers of this service. So where it comes to your British citizen or Irish citizen employees or potential employees, you will still need to conduct those manual checks and keep the copies of the documents that have been noted with the date, time, and the fact that the document was checked in the presence of the owner. Now, takeaways. I know it's nearly lunchtime, and unfortunately we're not talking about Deliveroo. What we hope you have got from this presentation is that a sense of what you need to be keeping in terms of your documentary requirements. Because of the changes to the right to work checks, I would check your HR policies and procedures and updating them as necessary. You need to maintain your record keeping in lieu of the past labour market tests. And finally, we would say don't panic. If your records are not up to date or correct, this can be rectified. If your reports on your sponsor management system are not up to date, it is better to report late than not to report at all. So we have got a repeat of the poll that we had at the beginning of the presentation to see, really to check if me and Lydia have done any good at all during the hour that we've spent together. So how do people feel now? I think
so
that's
good.
Pretty good. I think
no one doesn't know what they're doing.
No, exactly.
Most people are still somewhat confident or very confident. Very confident, I think, has gone up significantly. That's great. That's good to see.
Great.
Going backwards.
Why is that going backwards?
Keep clicking.
Bit of a technology issue. Why is that going backwards? Okay, Sam, I need help.
So let's get on to the next slide. There we go.
And the next one. So I think we can probably deal with some of the questions. I've seen quite a few questions pop up in the Q&A and the chat as we've been going along. Sam, what have we got?
Yeah, so just to cover a couple of general points first. We've had a lot of people asking about slides and the recording, so just to give people peace of mind, we are going to send you the slides, we are going to send you a copy of the recording, so you will get that. We've also had a few people contacting us directly about a couple of kind of technical and sound issues. Just for reassurance, those were, again, to our knowledge, those are specific issues that people have been having at their end. So if those of you who have those issues are still here, again, you will have a copy of the recording. In terms of the kind of questions we're going to answer, we're going to try and keep it to the topics that we've been talking about today. If we do have time, then we've had some more general sponsor license questions that I'll put to you as well.
Okay.
And equally, we've had a few questions, again, most of these sent to us very directly, which are very case specific.
Mm-hmm.
We're going to try and avoid those for the time being. For two reasons, really. One, because some of this stuff is going to be commercially sensitive at your end, and we don't want to risk kind of distributing recording of that stuff on that you don't want going out. And equally, there might be some kind of issues and factors that we're not aware of that anything that we say could be misleading. So we're going to keep it to the more general questions. But for reassurance, if you have posted a question, we have seen it, and we'll do our best to kind of go through most of this. So just in terms of kind of getting us started with some nice and straightforward ones, we've had people ask about kind of those who have already hired people on, for example, graduate visa or other visas, where you're not required to do a resident labour market test, and then moving into visas where you would be required to do a resident labour market test. What are the obligations they have in those cases?
Okay, so where you've got someone who's on another visa and they're basically switching immigration category but staying with you, that's a really good example of a time when you're not necessarily going to have that recruitment evidence. And this is a situation where coming up with something else would be a good idea. So if, for example, you've got someone on a graduate visa, perhaps, or a dependent visa, and they are switching into skilled worker, I think good documents to keep would be their original recruitment records. Again, you should be retaining things like interview notes for people anyway. So if you do retain those, and then it would be sensible, for example, to have perhaps appraisals showing that they have met their targets, or their or the training that they've undergone with you, and if you are promoting them, I guess, evidence of that. But where you know from your own experience that they can do the job, and if they don't have an appraisal, I would suggest just sort of a detailed written note setting out in a narrative form that they've already started working for you, the types of work that they've been doing for you. If it's the same work, then you can simply say they've been doing all of this for us for 2 years. They've had very successful appraisals, and therefore we know that they're suitable to carry out the work going forward.
Brilliant. And this is kind of one that we covered a little bit in the presentation, but in terms of the resident labour market test, we've talked about how that there's a new system and an old system.
Yeah.
How do employers know which of those that they need to do?
Okay, so if you're employing skilled workers, the resident labour market test, the very difficult, onerous old one, is now gone. Off the top of my head, I've got a table here of who has to still do the resident labour market test. I think you still have to do it if you're recruiting a minister of religion. I have done some minister of religions in the past. Creative workers as well. Again, I haven't really covered that so much in this presentation because it's not such a familiar type of sponsorship that you deal with more commonly. But those need to do a resident labour market test. And international sports person. Those are the 3 routes where you still have to do the RLMT. But if you're recruiting skilled workers, then the very onerous resident labour market test does not apply and has not applied since December 2020. 1st of December 2020.
Yeah.
Okay, and Sally, this is kind of one for you really, but we had a kind of question fairly early on in terms of renewals.
Mm-hmm.
So when a employer makes a renewal,
Mm-hmm.
what is the impact does that have on their license? Does it trigger any kind of automatic suspension? Can they continue going as normal? How does that work?
Okay, so when your licence is coming up for renewal, you will, about 3 months before the expiry date, the authorising officer on the licence will receive an email from the Home Office that is automated, advising them that the renewal window is open. If you have maybe not been the best at kind of reviewing your licence regularly for the 4 years that you've had it, that 3 month period would be a good time to make sure that everything is up to date, that your company address is up to date, that your sponsored workers are still sponsored, and that kind of thing. The renewal window is most likely when a compliance audit will be triggered, but generally only if the Home Office have any feeling that you have not complied with your duties. So I haven't had, certainly in the last 24 months, I haven't had a renewal where the Home Office have actually conducted a compliance audit, but that's not to say that it won't happen. You need to renew the licence within that renewal period and certainly before it expires, but your last day is the expiry date. What happens then is similar to what happens with sponsored workers or migrants who make an application for an extension, and that your licence will continue as it is, and you can continue to sponsor your workers until the decision has been made on your licence, and one would hope that you will just get a decision which renews the licence for a further 4 years. Does that answer the question?
Yeah.
Yeah.
So we've had another question, so I'm just pulling it up so I can refer to it directly. So when you've got an ongoing recruitment process in place, so the example we've been given is where you are always advertising for a specific role, because maybe you have a high turnover, maybe you have a high need for that role. What is the kind of example of records that they need to keep? Do they can they use the ongoing advertisements, or do they have to, because we talked about having to have specific starts and end dates for adverts? What's the impact for those kinds of...
Okay, so for the moment, from now going forward, if you're using a rolling recruitment campaign, I would still retain a copy of where you're posting it. If you're posting it in the same places all the time, on your own website perhaps, or on, I don't know, Indeed or any of those others, I would still maintain the wording that you're using, and ideally try and keep that wording consistent. I sometimes come across employers who sort of have changed the wording a number of times, so if you do that, you're going to have to keep copies of all of them and sort of think about which one did this person respond to. If you're running rolling recruitment, I would simply keep a narrative note that this is a rolling recruitment campaign that you have open all of the time. I don't anticipate that being a problem if it is a rolling recruitment campaign. You can sometimes, some of those online portals, for example, will allow you to see the metrics of, so how many people have clicked on a job, how many people have submitted an application. So you can also retain that. But I don't think it's a no-no. I don't think it's a problem, as long as it's clear to someone outside coming in that that's what it is and that's what you're doing.
Brilliant. One really common thing we've had is about changes to the circumstances of employees. Mm-hmm. So these can be changes of salary, kind of promotions of job roles, and including kind of when people leave. So what are the changes that they have to report? And you've spoken a bit about timeframes, but those timeframes as well.
Yeah, so most change of circumstances for migrant reports need to be made within 10 working days. Things that you don't need to report are kind of incremental increases in salary. That's not a major cause for any concern and wouldn't trigger a report. Where you promote an employee, you need to be very careful to make sure that their new role, their promotion, still sits comfortably within the standard occupation classification code that you assigned at the time that you assigned the certificate. If you have an employee that you have promoted and given an increase in salary because of that promotion, their duties have changed slightly, but they remain within that same standard occupation classification code, then you can simply report a change of circumstances on the sponsor management system. If that employee has changed their role completely because of this promotion, and they would then fall under a different standard occupation classification code, you will need to issue a new certificate from your undefined certificate year-in allocation, and that employee will need to submit a change of employment application to the Home Office, which is effectively an in-country extension application. So although we refer to them as change of employment, it is effectively an extension application. Where you have an employee who's maybe they get married and they want to switch into a spouse visa, so they don't need sponsorship anymore, then you need to make the report for the last day that you are sponsoring them. So the day that you check their right to work for their spouse status will be the day that the sponsorship terminates, and so you need to report that within 10 working days of the termination. Again, if your sponsored worker switches into an indefinite leave to remain, you need to report the last day that they were sponsored, and again, if they leave your employment or you terminate their employment, the termination date is the date which you count that 10 working dates from. If you are reducing hours, if you are reducing salary, you need to be very careful to make sure that the salary still meets the minimum required by their standard occupational classification code. But these are the types of things that need to be reported as a change in circumstances.
And just to kind of clarify a specific point on that, where there hasn't been a change in circumstances, where you're employing somebody, maybe you're a year, 18 months into their sponsorship and their circumstances remain the same, do you have an ongoing obligation to make any reports to the Home Office?
No, you don't have to. But what we would suggest to sponsor licence holders is where you are not sponsoring lots and lots of people. So maybe you've got 1 or 2 sponsored workers, and actually you don't really look at your licence because you're happy with your sponsored workers and they're doing their job and everything's marvellous, and so you're not looking at your sponsor management system very often because you don't have to, because nothing is happening. I would suggest that at least every month or 2 you log in, your level 1 user logs into the system and just has a look at it, because the Home Office do keep track of sponsors' activity on the system, and if there has been no activity for 12 months they will ring you and say, why aren't you using your system? And you can say to them, because everything is just wonderful and I don't need to, but you just as a matter of course you should be logging in just to check your messages. On the first page of the sponsor management system, you will have messages from the Home Office about changes in the rules and things. So just keep up to date and make sure you're logging in so that the licence doesn't become effectively dormant, because you will get chased, and if they can't get hold of you then they will make your licence dormant.
Yeah, the other thing I would add to that is, even if you're not having to report things, it's worth showing that you've got a process for checking in with those sponsored workers periodically, to do things like check if they've moved house or got a new phone number, because you're expected to retain that record. It can be useful to have a system for checking in with them, I don't know, once every 3 months, once every 6 months, asking them to actively confirm that they haven't moved or that their number's the same, rather than just assuming that they will tell you. And similarly, just checking in with them to say, can you just confirm if you've moved on, you've applied for any other a different type of visa, for example, so that if you are ever audited, you can show that you're actively checking that and therefore actively complying with your duty on an ongoing basis, even if there's nothing to tell the Home Office.
Okay, one that we've had from a few different people is about criminal record checks. Okay. So what is the standard to criminal record checks that they have to meet, and when is it acceptable to use a kind of UK-based criminal record check versus an overseas criminal record check?
Okay, so there is a list of standard occupation code where a CRB check or a criminal record certificate is required. It's a relatively long list. It's published within the immigration rules and also within the sponsor guidance. I couldn't list all of them off the top of my head, but typically it's people who work in things like, who work with vulnerable people, so people who work in healthcare, people who may work in social services, teachers, people like that. The things you would expect, and to be honest, the sorts of employment where you're highly likely to be checking someone's criminal record anyway. If you're recruiting someone who's been outside the UK, ever really, since they were 18 or in the last 10 years, and they spent 12 months or more outside the UK, you may also need to get a criminal record certificate from that country. There's guidance on the Home Office website. If you Google criminal record UKVI, you'll find it, that gives an indication of roughly what someone would have to do in each country. Very occasionally there are countries where it's just not possible.
Iran,
Afghanistan, I would have thought you'd struggle to get a criminal record certificate because of for various reasons, and that website will indicate what you have to do in that scenario. Often I think they will ask for a sworn statement or similar.
Okay, in terms of where people use agency workers, so we've had a few questions where people have said, where agency workers are being used, who is responsible for making those right to work checks, and equally, how does that relate to sponsorship? Do they need to sponsor those workers directly? Can they use agency workers who are coming from overseas?
The agency, the person who employs the worker is responsible for the right to work check.
So in some cases, the agency will employ the individual, and there will be a contract of employment between the individual and the agency. So in those cases, the agency does the right to work check. In terms of sponsorship, the person who is using, that's a terrible phrase, but the person who is employing the services of the worker needs to be the person who is the sponsor. So what we get inquiries about often, and what you can't do is you can't get a license as an agency to sponsor sponsored workers and then provide them as labour to a third party. That's simply not permitted. The Home Office guidance is very clear that the organisation that has the sponsor licence needs to be the one that is controlling the person's duties, for example, and that has day-to-day control over their work. Sometimes that's not as clear-cut as it sounds, but the Home Office are very clear that you must not be using it simply to provide. You must not use your sponsor licence simply to provide agency labour to someone else.
Okay, and we've had a couple of questions about so the documents that people retain. So the example that's been given by a few different people is passports. So when you're taking a passport, what do you need to take? Do you need to take kind of cover to cover the whole thing? Does it need to be coloured copy? Is a just biometric page okay?
You certainly need a really good clear colour copy. Well, it needs to be a very clear copy of that photo page. Biodata page. So the one that's got photograph on it and also name, date of birth, all of that stuff. It needs to be a clear copy. So I've certainly had cases where the Home Office have issued penalties because someone's taken a copy, but it's useless. You can't see who the person is. You also need to take a copy of any page which shows that they have the right to work for you. Increasingly, there are not going to be very many cases where someone has a stamp in their passport on which you can rely. But, for example, if you've got someone who is your own sponsored worker who is coming in and you're relying on that wet ink stamp when they come in, you would need a copy of that page. Historically, they asked you to take a copy of the front cover. I don't think that's a requirement anymore, but it doesn't hurt to take a good clear copy of just the front cover. You don't necessarily need to copy every single page. You don't need copies of 25 blank pages in a passport.
In terms of workers who are largely kind of remote workers but who are still eligible for sponsorship, so maybe they don't spend all week in the office, sometimes they spend time out of the office. It's kind of a bit of a two-part question that's come up a few times, but in terms of monitoring, what kind of records should you be keeping of monitoring? And when that goes wrong, when people don't turn up for work and you're concerned that they have kind of absconded, how should you be reporting that to the Home Office?
So the Home Office traditionally really liked sponsors to have a kind of physical presence where workers would attend and kind of clock in and clock out, and you could then see when your workers were at the office, at their place of work, doing whatever they were doing. Because of COVID, the Home Office have had to kind of get with the programme in terms of remote working, because lots of people have had to remote work over the past 2 years. So what we would suggest to people who have remote workers is that the company has an operating system which allows them to monitor when people are working. So if we've got, as an example, where we work with kind of tech clients, they usually have they work from Slack, for example, and so people's projects and things are on that operating system. Some people have project management operating system, so you can see there's obviously kind of remote like Zoom team meetings, and so I think it's quite easy to continue to monitor your workers when they're working remotely. Where you've got people where you think they might have absconded, if they've not turned up for work, then if they haven't turned up for their first day of work, then that needs to be reported via the sponsor management system within 10 working days. As Lydia said earlier, if you've got somebody who's gone AWOL and have not been paid for 4 weeks, then you need to be reporting that person has gone missing. And again, that's the sort of 10 working day deadline for reporting that in the system. But most remote workers, their employees know that they're working because they have produced something, whether it be, you know, a project or a bill or, you know, something. So most workers, most employees do know that their employees are working, and whilst you might not have specific records of that, I think where projects have been completed and things, that's sufficient.
Yeah.
Yeah.
The only other type of case I can think of is where you've got workers who are maybe out working in the community. Domiciliary care workers are a classic. You might also have nursing staff who are going out into the community. There's no hard and fast kind of guidance as to exactly what you must keep, but in my experience, a lot of those clients tend to have often some kind of app-based system where they check in and check out, sometimes on a device at each service user's home. So that's another common way of doing it. Another kind of, I've even had clients who use, if someone's got a company vehicle tracking, could all be good options.
And other kind of changes that you need to report. So again, for example, your office changes. Does that need to be done through the sponsor license system or
Yes.
Yeah.
The SMS is essentially the portal through which you report virtually everything to the Home Office. It's designed to be the way, sort of, the medium of communication with them. If there's something that really you can't work out how to report it on the SMS, then you can always email the business help desk. But that portal is intended to be the way that you administer your license for pretty much all reports that need to be made. We are hoping to get a new sponsorship management system, possibly later this year, which can't come soon enough, to be honest, because the existing one is increasingly old and creaky. But yeah, if you need assistance with making reports, that's something that we can advise on.
And we've got these are a couple of more broader sponsor license questions, but they're kind of questions that we all have on a day-to-day basis anyway, so it's worth addressing. Charges for fees, so application fee, immigration health surcharge fee, travel relocation fees. What can an employer pass on to their employee, and what do they need to pay themselves?
So employers can never pass on costs that are directly related to the certificate. So where you're paying an immigration skills charge, you can't pass that on. Where you are applying for a new licence or renewal, you can't pass that on. The certificate assignment fee, the £199 that you have to pay for most certificates, you cannot pass on. What we tend to see in practice is companies paying, application fees for entry clearance, immigration health surcharges where they're applicable, or applications for extensions. Employers paying those fees up front, but then speaking to an employment lawyer and having a clawback agreement in the contract of employment, whereby if your employee leaves within 12 months of service, they have to pay everything back. If they leave within 12 and 18 months, then it's 80%, 18 to 24, 60%, and so on and so on. So you've got a 3-year period where you can claw back some of your costs. There are going to be costs that are just not reasonable for you to claim back. So if you pay the immigration health surcharge, which you obviously have to pay up front, and you pay 5 years, for example, and your employee leaves after 2 years, you will get 3 years of that immigration health surcharge paid back, because you get it paid back on a 6 monthly pro rata basis. So it's not necessarily reasonable for you to, well, it's certainly not reasonable for you to claim the whole 5 years back, because you are going to get some of that back from the Home Office. But we are not employment lawyers, so if you want to kind of speak or have some kind of clawback or loan agreement in the contract of employment with your employee, you would need to speak to an employment lawyer about having that set out and what would be reasonable.
Yeah.
And this is another kind of general sponsor license question, but there's been a little confusion over kind of allocations and kind of particularly people who are concerned about urgency in terms of hiring. Can you talk a little bit about the distinction between a defined certificate of sponsorship and an undefined certificate of sponsorship?
Yeah.
And where you need to increase your allocation, are there ways to kind of expedite that process?
Yeah. Okay. So undefined certificates will sit in your sponsor management system until you use them for a period of 12 months, which starts from the date that your licence was granted and ends the following year, the day before your licence expires. Undefined certificates can only be assigned to people who are already in the UK and require sponsorship. So you might have somebody who's switching from a student to a skilled worker, or a spouse visa to skilled worker, or a switching application, or coming from another employer. So those undefined certificates can be assigned to people who are in the UK. If you don't have any in your system for some reason, if you don't have a year in allocation, then you can make ad hoc requests via the sponsor management system for the number of certificates that you need. This process does, as I'm sure you're aware, which is why the question has come up, take 18 weeks. Quite why it takes so long, I'm not entirely sure. But there is a way of expediting it. So the Home Office do offer and it's called the Post Licence Priority Service. And this Post Licence Priority Service opens at 9 a.m. every weekday morning. And you fill in a Post Licence Priority form, which is available on the Home Office website, and you send that to the Post Licence Priority email address, setting out what type of application that you've made through the sponsor management system, your sponsor license number, and if you are successful in securing one of those priority slots, you will get two separate emails, one saying your application will be dealt with on a priority, and another one with a payment link, and you have to pay £200 for the priority service, and then you should get the decision within 5 working days. There are 30 slots available every day, and I have never not been successful in securing a slot since forever. They don't get used up that quickly. I think as long as you send your email at 9 o'clock on the nose, you should be able to secure that priority service. Defined certificates you apply for on an ad hoc basis via your sponsor management system as and when you need them. They do not sit in your system waiting for you to assign them. Defined certificates are needed to support all applications for entry clearance. So people who are coming from outside the UK always need a defined certificate. You make the application through the system, and in normal circumstances you will get a decision within 24 hours. As long as it's on a working day. So if you apply on a Friday, you should get the decision on a Monday. There are certain standard occupational classification codes that the Home Office tend to require more information on, and so what we see tends to be for senior care workers. Most of the time the Home Office want extra information. For business development professionals, the Home Office tend to want extra information, but for most SOC codes it's a 24-hour turnaround.
Okay.
Anything to add?
No, I think that's it. Hospitality, sometimes you get a bit of pushback from them on hospitality, so they might come back and ask you for a load more information.
Lydia, this is kind of one for you, and it's something you kind of talked a little bit about in your presentation. But where you have people who have come to the UK and don't have their BLP yet, and similarly people who are required to undertake certain professional checks such as DBS checks. Those obviously can take time to pull together. What are the checks that you need to do before you receive those? Or this is probably the wrong way around to ask the question, but are workers able to
start
begin
work
working
with that
before they receive those? And if so, what are the checks that you need to do at that stage?
So I'll start off with the BRP, and I think we cover this in the right to work check, but the right to work check is quite complicated. So if you've got someone who's coming in from outside the UK as a skilled worker, in almost all cases, not almost all cases, but in the majority of cases, they will have that vignette in their passport. And usually the officer at the airport, for example, as they come through immigration, will stamp that to show the date that they entered. So when they very first arrive, before they get their BRP, you can rely on that for your right to work check. And then once they get their BRP, you need to rerun the right to work check using the share code that they'll be able to get from their BRP. Obviously, if they're here, then they must at least have that. The other option is that you have those people who get electronic only, so that's likely to be EU nationals who don't get any documentation at all to confirm their leave. It's online only. Those people you would use a share code from the beginning. So you should be able to get that straight away on their first day of employment. So you must do that before they start work. In relation to your criminal record checks, I suspect this is in some ways less an immigration, rather than more a general kind of employment or regulatory issue, where DBS checks are needed. I would have thought you really need those before someone starts work. So from an immigration point of view, usually if someone's not been here before, then you're looking at criminal record certificates from abroad, from whichever country they've been living in, and I would say that you need those, I think, before they start work. I would have thought as a general rule, if someone needs a DBS check, you need to get it before they start work, in case you are accidentally employing someone who has serious convictions. It's no use finding it out 3 weeks after they start.
Yeah, I mean, DBS checks are for UK-based people anyway.
Yeah.
The criminal records checks that are required for those occupations that Lydia mentions examples of earlier, the overseas criminal records check, except from countries where you're just not going to be able to get one, that has to be done before you apply for entry clearance. There's absolutely no point in applying for entry clearance if you need a criminal records check, because without it the application will be rejected. Because on the application form you need to write whether or not your profession is one that needs a criminal records check, and the criminal records check needs to cover any country that you have lived in for more than 12 months, whether or not that's a consecutive 12 months or whether it's kind of split up, for the last 10 years or since you were the age of 18. So if you've lived in as a student doctor in the States for 3 years, and then you moved home to India, say, for 2 years, and then you moved to a European country, you would need a criminal records check for all of those countries before you applied for entry clearance.
Okay, and on a similar vein in terms of kind of criminal record checks, where somebody is already here, they're already employed by their sponsor, and they get into trouble with the law while they're here. Not trouble that's going to get them fired from their work, but they're where maybe they pick up a fixed penalty notice, or maybe something a little more serious, but the employer is still happy to continue sponsoring them. Do they need to report that to the Home Office? And kind of, if so, where's that line in terms of what they need to report?
It really depends on the offence, I would say. I mean, a fixed penalty notice is
you
don't have to report that.
You don't need to report that.
And driving in a bus lane is not a criminal offence. You'll get a local authority fine for that.
I can't think of any section of the guidance that would require the sponsor to report a criminal offence. Thinking of, I've never read that in any of the sponsor guidance that I can think of. What will happen, however, is that eventually when that individual comes to apply for their next grant of leave, indefinite leave to remain or an extension or whatever, they will have to declare it. And at that point, the Home Office will become aware of it. There are defined rules for them as to when that will lead to the refusal of a visa. If you're continuing to employ them, I take it that is likely to mean that they're getting a non-custodial sentence. I mean, if they go to a prison, you're going to have to report that because you're going to have to stop sponsoring them. And I assume you probably wouldn't want to employ them through that period. So it's likely, therefore, to be something on the very less serious end, in which case it's probably not going to lead to refusal either of a future application if it's non-custodial. They'll just need to know to declare it.
Yeah, and I mean all of those kind of offences need to be disclosed on a future application.
Yeah, but that's an application made by the individual worker themselves rather than by you.
Yeah.
Okay, and kind of moving topics a little bit here, but in terms of pay and making sure that you're paying the correct amounts, where people are doing, where people are having a slight change in their pay, but it's not permanent. For example, maybe they have a bonus, or maybe they do overtime, but these are kind of temporary one-off occurrences. Is this something that affects, do you need to put a sponsor note on the cause, do you need to make reporting, or is that just something that can just happen?
No, that can just happen. Small incremental increases in salary, one-off bonuses, all of these kind of non-guaranteed, potentially, salary changes don't need to be reported. It's the significant changes that need to be reported.
And in particular, I think changes going down. So the Home Office are less worried about someone's pay going up, because that's not going to bring them in breach of the immigration rules. It's when pay is being reduced for any reason that you need to be particularly careful. That would include things like you need to report if someone goes on maternity or paternity pay, for example, for a period. That does need to be reported. You don't need to stop sponsoring someone, but you just need to let them know so that in future, when they check their pay records, they can see that the reason they've had this big drop in pay is because they've been on maternity leave or sick leave, for example, if they go on to sick pay. Those need to be reported, but over time that puts their pay up. You don't need to report that.
Okay, we've had a couple of questions actually about us.
Okay.
So what support can we provide? What are the services that we can offer for those who can already have a sponsor license? They don't need our help applying for anything, but maybe they would like our support in terms of managing and renewing their sponsor license. What can we do for people?
So we can conduct a kind of audit of your sponsor license to make sure everything's up to date. That can be done remotely at the point of renewal, so we can make sure everything is up to date. Just for ongoing support, if we are named as your representatives on the license, then it's fairly easy for us to become a level 1 user, which would give us full access to the system, and will allow us to make the reports that maybe you don't want to make or don't have time to make. We can assist with the renewal of the license.
We can also provide sort of
just ad hoc.
One-off ad hoc advice.
Yeah.
So if you've got a couple of particularly sticky issues that you're not sure about, then it may be a case where we can charge you either a relatively low fixed fee or on an hourly rate basis if it's not something that's going to take very long. Just talk you through that, put your mind at rest, maybe provide a small amount of written advice on a particular issue, and that might be all the only help that you need.
We've helped companies who are not sure about assigning a certificate where they've got a new employee, so we can help assign a certificate, and we do all of that via Zoom on screen sharing, and we can walk you through most things on the system with the wonders of modern technology and screen sharing.
So we can be quite flexible, I think, as well in the services that we offer, depending on what level of support you need.
Yeah.
So a couple of final themes. So we're reaching the end of some of these questions. Just for a bit of reassurance, there's a few people who've had very, very specific questions.
Yep.
I have made a note of your names, and I will kind of get in touch with you directly after this. So if we're not answering a very specific question that you've asked, that is why we're not ignoring you. In terms of people who leave the job, so we've kind of had a couple of questions which follow a similar theme to this. So you mentioned when you were speaking earlier about how it is your responsibility to let the Home Office know if they get ILR or move on to a different visa. Are there mandatory follow-up periods that employers need to do these checks with people to find out whether they have moved or what they have done? And similarly, for those who aren't moving on to another visa, we've had a couple of people ask, once they've left our employment, how long do they have to leave the UK? And is it our responsibility to make sure that we get proof that they've done that?
Right, okay. So just dealing with that final question first, it's not your responsibility to make sure that these people have left the UK. So where employment has been terminated for whatever reason, and you have reported on the sponsor management system within that 10 working days of the termination date that you no longer sponsor that migrant, they are no longer your responsibility. That's it, job done, you don't have to do anything else. That report on the sponsor management system should trigger the Home Office to send a curtailment letter, and that's why it's really important that you keep up-to-date contact details for your sponsored employers, as Lydia said earlier. So the Home Office, when you make the report, will want an address, the last known address, an email address if possible, and a telephone number if possible. The Home Office will then send out a curtailment letter, and that curtailment letter will curtail that migrant's leave to 60 days unless there is less than 60 days left on their status anyway. Now, the thing with these curtailment letters at the moment is that the Home Office is taking ages to send them. It's taking months and months, and so these people have no obligation to leave the UK until they've got their curtailment letter if they don't want to, and that potentially gives them a lot more time to find an alternative sponsor. But the important thing for you is, as long as you have made that report, that's it. You no longer have responsibility for that migrant. It's not your problem if they leave the UK or not. And sorry, Sam, what was the other question?
So the other question was kind of, are there mandatory follow-up periods where you have to check? So you mentioned, within the next 12 months after they've left your employment, you need to notify the Home Office in terms of when they move on to ILR or other visas. Are there mandatory periods?
Yeah, you only make the report once in the system, and once you've reported that person has switched immigration routes or left your employment, that's it. You don't have to go back to the sponsor management system. I mean, that would be bonkers if you had to kind of chase up these people after they'd left your employment or changed their status, even if they're still working for you. So it's just that single report.
Yeah, but that report should be made within 10 working days.
Within the 10 working days.
If you miss the 10 working days, don't just leave it. Report
it
late
anyway.
rather than if you report a couple of days late, you shouldn't do it. You shouldn't be late, but in the grand scheme of things,
as
if
long
the
as it's
report
on there.
gets made, it's unlikely to be a major issue. If you look back after this webinar and realise suddenly, oh heck, there's 50 reports that we should have made and we haven't, then that's a situation where you might want to get in touch with us for a bit of advice. If you suddenly make 50 reports all in a day, you might need to have a think about that one.
Yes.
So if that's the position you're in, drop us a line.
And we've just got two more questions. So, COS expiries. So it's a more general question.
Okay.
Once a COS has been issued, when do they expire? And how long have you got to assign one? And once they've been assigned, how long have you got for the person to get their visa?
3 months and another 3 months. So with a defined COS, so that's the type for entry clearance where you have to request them on a case-by-case basis. They will land in your sponsorship management system. You then got 3 months to assign them, and then once you've assigned them, you've then the migrant then has a further 3 months in which to use them. That said, you've got to keep in mind the actual start date, the work start date. So it might be that in theory they've got 3 months to use the certificate of sponsorship, but if their start date is in 2 months' time, they obviously can't wait that long. And there are separate rules about how long after their start date people can arrive. But yeah, 3 months and 3 months.
And the last question we got relates to audits.
Mm-hmm.
So when the Home Office make an audit to go and look at a company, and this is where somebody's already got a sponsor license in particular, will they want to see the employees as well?
Yes.
Yeah. I mean, usually when you have an announced visit, you will be informed beforehand who the Home Office want to speak to. So they will always want to speak to your authorising officer, because that's the person who's responsible for the licence. If the authorising officer and the level 1 user are not the same person, they might want to speak to the level 1 user as well, and they will want to speak to some of your sponsored workers. Maybe not all of them, but it will really depend on the nature of the audit and why the Home Office are visiting. If it is announced, they will send you a list of the people that they want to speak to. If it's unannounced, it's a bit more difficult, and so if you've got people, for example, who are working in the care sector, and your sponsored workers are out visiting service users because you're providing domiciliary care, that's more difficult, because you may have to just recall them quickly and send somebody else out to do their work that day. Where you've got workers, say, who are working in construction or in industry where they're working on site, again, if it's an unannounced visit, it's more difficult, because you might just have to recall those people for that day. Where you've got people working in industry and working on site anyway, the Home Office usually want unfettered access to the sites that they're working on, to make sure that your sponsored employees remain under your control and are not controlled by the foreman on the site, for example.
Yeah.
So it varies by degrees, really.
And the point I would add to that is about the address that you put on the certificate of sponsorship. If particularly where people are working away from the main site, or if people are working from home even, or if they're working on client sites, and therefore their main place of work or a secondary place of work changes, that's when you've got to think carefully about updating that, with reporting that, because if the Home Office do decide to undertake an unannounced visit, they're going to turn up at the address that you've given them. And if they turn up at the address that you've given them and it's an empty office, or none of the people are there that they're looking for, that is not a good look.
No.
Yeah. So be aware of that when. I mean, it's another issue for if you do have workers who work for a lot of the time from home. Say someone's 3 days in the office, 2 days from home. You should probably put their home address on the certificate of sponsorship as a secondary place of work, and they need to be aware that it's possible the Home Office might knock on the door one day to interview them. Well, not necessarily likely, but that's possible.
Yeah.
Brilliant, thank you very much. We've had in total, between the kind of chat function and the Q&A function, over 100 questions. So
wow.
we've done our best to kind of collate these into kind of common themes and answer them where they are. Obviously, our contact details are on the screen. I think we're going to leave that up for a little bit as well. So if you do have any follow-up questions, please get in touch, and we'll come back to you as quickly as we can.
Brilliant. Okay. Lovely. Thanks for joining us, everybody, and we will see you next time. I understand that the recording and the slides will come out to you on Monday. So have a great weekend, everyone, and we will see you next time.